Hello, welcome to Reading Decisions. My name's Diana. I'm a lawyer in Nova Scotia, and I read decisions from courts all over the country. And today's case is coming from Quebec. As always, mispronunciation or errors are my own. I'll make sure to leave a link to access the case from the source site, and you'll be able to see that in the description. So today's case, Gallaman Schwartz, 2023 QCCS 1607, as accessed on CanLII from the province of Quebec, District of Montreal, Superior Court, by the Honorable Pierre Nollet, JSC. Overview. Joe Gallaman wishes to receive an advance payment on his share of his father's inheritance. The liquidators to the estate and Joel's two sisters, heirs under a will and codicil, object. Joel contests their decision. His recourse must fail as the liquidator's decision is reasonable. Analysis. 1.1 Facts relevant to the issue. Michael Gallaman passed away in Montreal on December 24, 2017. Joel and his sisters, Helene Gallaman Schwartz and Eliza Gallaman Guaza, are his three children. On August 5, 2015, Michael signed a notarized will before me, Sheldon Merling, notary. The will. In the will, Joel, Helene, and Eliza inherit in equal shares Michael's shareholdings in an investment company, JHA Investments, Inc., as well as his undivided 10% personal right, title, and interest in Place Kensington. Joe, Helen, and Eliza were also made the residual universal heirs of the estate in equal share. In the will, Michael appointed 3 liquidators, amongst which are his 2 daughters. On November 17, 2016, Michael signed a notarized codicil to the will before me, Abby Malkinson, notary, the codicil. The key change brought by this codicil was to remove Helene and Eliza as liquidators and replace them with Sheldon Merling, notary, and Serge Segal, attorney, who, with Eli Uman CA, shall act as 3 independent liquidators, the liquidators. According to the codicil, the appointment of independent liquidators was deemed necessary to avoid controversy and friction amongst the 3 siblings, and allow for a harmonious allocation and distribution. In July 2017, prior to Michael's death, Helene and Eliza initiated a campaign questioning Michael's change of banking institutions as well as his behavior. There followed a series of letters between the parties' attorneys, the sisters opting to retain 3 different and successive attorneys who requested that Michael undergo psychiatric evaluations. In September and October 2017, Michael underwent a neuropsychological evaluation and a psychiatric assessment. On November 2nd, Michael signed a power of attorney, replacing Helene as one of the 3 attorneys by his companion, Miss Anne Slim Danziger. The second and third attorneys, Joel and Eli Ullman CA, remained. Joel contends that at that time, Michael also provided his notary with instructions to change his will to remove Helene and Eliza as his heirs. To the extent this is true, this change was never implemented. After Michael's death, his liquidators proceeded to liquidate the assets as directed by Article 4 of the will. Amongst other things, the liquidators engaged into a tax planning exercise using the services of me, Paul Ryan, to avoid a common double taxation problem. While this process was ongoing, Joel announced his intention to launch legal proceedings to challenge the validity of the will and have a holograph will exemplified in its stead. In the meantime, 2 tax strategies were devised by the tax advisors. The liquidators agreed to the first of 2 strategies. The first strategy and provided notice to the heirs and their intent to adopt several resolutions to enable the first strategy, mandate a law firm to prepare the required documentation, distribute all amounts to the estate which could be distributed on a tax-free basis. The last of those resolutions reads as follows: that the assets of the estate be distributed to the heirs as soon as feasibly possible after A. Any possible contestation of the will has been eliminated or resolved. B. The above transactions have been completed. C. All applicable taxes have been paid. D. The required distribution certificates have been obtained by the tax authorities. E. All other formalities prescribed by law have been accomplished. All 3 heirs were informed of the pending approval of these resolutions and none opposed. The liquidators adopted them on October 26, 2018. A month and a half later, Joel introduced an application to have Helene and Eliza declared unworthy to inherit because of their allegedly serious reprehensible conduct that would have taken place between May 2016 and October 2017. The application initially sought to have Joel declared as to be Michael's sole heir. At the same time, Joel sought a first safeguard order to prevent the liquidators from distributing the proceeds of the estate to his two siblings. The order was denied on the basis that Joel had not shown urgency nor a strong appearance of right, the judge noting that Michael was aware of the behavior of his daughters for over 18 months and still chose not to disinherit them. Joel then introduced the present proceedings, asking that he be given his uncontested share of the estate. He requested a second safeguard order for an advance payment of $250,000 while awaiting the hearing of the current application. Justice Louis Charette, JCS, dismissed the motion on the basis that his decision would preempt the current hearing already scheduled. The issue of unworthiness is scheduled to go to trial in January 2024. The plaintiff is now seeking to obtain 90% of the value of his inheritance as an advance payment pursuant to Section 807, CCQ, and 49 CCP. The liquidators object, invoking, amongst other things, that the 5 conditions set out for distribution in the 2018 resolution have not been met, as the contestation of the will has not been resolved and the distribution certificates have not been obtained from tax authorities. Helene and Eliza add that there is a strong lack of evidence of Joel's immediate need for money and therefore lack of urgency. Joel's arguments to obtain such advance payment are as follows. The estate is clearly solvent, having over $19 million in liquid assets and no debts. His 1/3 share of the estate is not contested. The liquidators are acting unreasonably by withholding his inheritance. He is 63 years old, has had no employment income since May 2016, when he allegedly stopped working to care for his father. The liquidators are also acting unreasonably by not taking any steps to increase the value of the estate. The liquidators have already paid bequests to 6 grandchildren, transferred Michael's condominium property to his companion, both without requesting the distribution certificates from tax authorities. All taxes have been paid, albeit the liquidators are unduly withholding the request to obtain the distribution certificates from the tax authorities. Legal principles. The application is based on Articles 807 CCQ and 49 CCP, which read as follows. 807. Where the succession is manifestly solvent, the liquidator, after ascertaining that all the creditors and legatees by particular title can be paid, may pay advances to the creditors of support and to the heirs and legatees by particular title of sums of money. The advances are imputed to the shares of those who receive them. The courts and judges, both in first instance and in appeal, have all the powers necessary to exercise their jurisdiction in Section 49. They may at any time and in all matters, even on their own initiative, grant injunctions or issue protection orders or orders to safeguard the property's rights for the period and subject to the conditions they determine. As well, they may make such orders as are appropriate to deal with situations for which no solution is provided by law, the court emphasizes. Discussion. The estate is clearly solvent, which is the main condition set by Article 807 CCQ. Helene and Eliza plead that Joel does not meet the test to obtain a safeguard order, specifically due to the lack of a demonstrated urgency. They must be reminded that a request under Article 807 CCQ is not in and of itself an application for a safeguard order. It is simply an interlocutory application which does not decide the merits of the dispute. Therefore, the criteria for a safeguard order do not apply, and a demonstration of urgency is not necessary. What reasons do the liquidators invoke not to make at least a partial distribution? According to the resolution taken by the liquidators at the opening of the succession, distribution to the heirs must take place as soon as possible after any dispute of the will and its codicil have been eliminated or resolved. All transactions, tax planning have been completed, all taxes have been paid, and the distribution certificates have been obtained from tax authorities. Of all these conditions, 2 have clearly been met: tax planning and taxes paid. The condition attached to the receipt of the distribution certificates does not suffice to prevent distribution, since it appears that these certificates, if they had been requested, would already have been obtained, the taxes having all been paid for quite some time now. Mere suggestions by the liquidators that some taxes could still be owing are speculative at best. In effect, the payment of taxes results from the tax planning they carried out, on the advice of specialists, as well as on the declarations they made at the time. The taxes then due were paid or should have been paid, save and except for the negligence of the liquidators to do so or any false declarations by them, which is not in evidence. The statute of limitations for any claim by the revenue agencies would now be acquired. Defendants and liquidators raise the possibility of having to compensate monies owed by the estate to Joel with damages. Joel would owe his siblings. At this point, this possibility is entirely speculative, as Joel has not been found responsible to pay anything to his siblings. Furthermore, the two debts would not meet the conditions for compensation. The damages are not liquidated, nor are they certain or payable. The parties are not the same, and the debts do not relate to benefits of the same nature. The only real condition remains the settlement of the contestation of the will. This being the case, should Joel's legal proceeding against his co-heirs serve indefinitely as a bulwark or excuse against the distribution of estate assets that are not otherwise contested? Indeed, whatever the outcome of the dispute on the merits of the declaration of unworthiness, Joel's share is not called into question. When the succession extends beyond 12 months and is clearly solvent, Article 807 CCQ provides that the liquidator may make an advance payment to the heirs. When the liquidator refuses to act, the heirs may apply to the court as no other remedies exist in law. Apart from the power to issue injunctions or safeguard orders, the second paragraph of Article 49 CCP is the one that grants the court the power to make appropriate orders to provide for cases where the law has not provided for a solution. On what basis should the court exercise this power? The first element to consider is the will of the deceased. Michael signed authentic acts which have, at least to date, an indisputable probative value. Unless and until a judgment does confirm the existence of a later will, the court must give effect to the will in the codicil. The codicil was drafted in November 2016 after the alleged acts of indignity had begun. Michael specified that he had replaced the two sisters as liquidators to ensure a harmonious liquidation and distribution of his estate. He did not remove them as heirs, notwithstanding the conflict that had arisen between them. When, in November 2017, Michael amended the power of attorneys to replace one of his daughters with his own companion as attorney, he did not amend his will at the same time. Although Joel now contends that his father had given such instructions, but the notary did not execute them in a timely manner. One thing is certain. Michael did not make it his priority to amend the will when he could have done so well before November 2017. He rather amended his power of attorneys. The second element, always part of the will of the deceased, is to entrust the responsibility of the liquidation and distribution of his estate to 3 trusted professionals. The will provides that the liquidators may act at their sole discretion. Except where serious reasons would warrant otherwise, the court must not only respect Michael's will, but also avoid usurping the tasks of the liquidators. The court may examine the reasonableness or otherwise of the decision of the liquidators to wait for the settlement of the dispute before undertaking the distribution, but must always keep in mind that Michael granted them full discretion in the exercise of their function. In this case, the liquidators have reasonable grounds to act as they are. In a July 2022 letter, the liquidators' lawyers explained those reasons. You failed to mention that the 4.5-year delay was caused solely by the initiation of legal proceedings by your own client. We must remind you that he has requested a stay of proceedings and multiple extensions of the deadline for the registration of the case. Simply put, the executors argue that if, as your client argues, he has been beset by missed opportunities to increase the value of his inheritance over the past few years, he need only look seriously inside. The liquidators wish to clarify their position. They hope to be able to proceed with the distribution of the estate with regular promptness and to be released within a reasonable time. These expectations were thwarted by your client's legal proceedings, which then had to be challenged by the other legatees, thus preventing the liquidators from immediately carrying out their duties. In this context, the liquidators would like to remind you that they took this position in the resolution of succession duly notified to all legatees, which they adopted on 26 October 2018. Although you have referred to the said resolution, you conveniently failed to mention or take into account in any way the very first statement in paragraph 5, namely 5, that the property of the succession be distributed to the heirs as soon as possible after A, Any dispute to the will has been eliminated or resolved, highlighted in letter. As one of the legatees, Joel is presumed to have consented to this condition, not having objected to it when he was informed of it prior to its adoption. This tacit acceptance occurred more than 4 years ago. Is the passing of time sufficient to call into question the decision maintained by the liquidators to wait for the settlement of the dispute? It is not. When Joel began his legal proceedings for a declaration of unworthiness, he knew full well that his proceedings would delay the distribution to the heirs. Further, Joel has somewhat been the author of his own misfortune, in that, according to the liquidators, he delayed the progress of his own legal proceedings by first requesting a stay of the proceedings, and then by asking and obtaining various extensions of the deadline for the inscription of the case. In turn, these delays postponed the settlement of the dispute and, consequently, the distribution of the assets to the estate. To accommodate Joel, the liquidators offered him to advance payments to all 3 heirs. Joel refused based on his challenge to their status as heiresses. The liquidators' decision to hold any advance payment to treat the 3 heirs of equal rank evenly is reasonable. Without admitting it openly, the liquidators also seem to want to avoid financing a judicial guerrilla. Indeed, on July 18, 2022, Joel wrote one of his brothers-in-law, "There is no way that the girls will win in court 1000%. They will lose no matter what Pearl tells you, and the children will never get anything because there is no representation. Murray, we go back a long way. Do the right thing, talk to your wife, and tell her they should have accepted my offer because it will only get worse for them and you. Keep flushing your money down the toilet. Dad took care of me financially, specifically to honor his wishes because he knew what they were capable of. So I have no problem paying for professional services if it allows me closer to honoring the wishes of fathers." By handing over a share of the inheritance only to Joel, the legal dispute between the parties is therefore only likely to worsen. This would also have the undesirable effect of delaying the liquidator's discharge while the legal battle continues and create an imbalance between the parties. While this is not, strictly speaking, a criterion to refuse to make an advance payment, it adds to the reasonableness of their decision. The liquidators, therefore, do not act unreasonably by refusing to distribute an advance payment, which would benefit only one of the heirs. For these reasons, the court denies plaintiff's application to obtain an advance payment on his share of Michael Gallaman's estate with costs. And that is the end of this decision. I was reading from the PDF, so you'll see a couple of versions there. I'm not sure if this was translated from a French decision. I don't see that noted, but you'll be able to check that out in the description link below. Thanks, and have a great day until next time.